Good morning, and thanks for joining us here on Condo Solutions. Monday morning from 9 o'clock or so until 10 o'clock or so, we talk about things that happen in your condos and HOAs, some of the things that you may be concerned about or want help with, maybe have some questions about. My name is Mark Breckbill. I'm a local CPA and a licensed community association manager, and have been practicing in this area for about 25 years. On the audit, tax, and of course, like I said, I also am involved with a license as a community association manager. But the guy that really makes it happen every Monday morning for the last 16 or 17 years or whatever, however long it's been, it seems like a lifetime. But anyway, is Peter Mullengarden. Peter's our attorney, and many of you know that have been listening for a long time. He's a great guy to get information from. Gives you the straight shoot and exactly what you need to know, and he's here for you. So he's going to help answer those questions and provide some of that information that you might need. So if you want to call in, the number is 220-9788. Again, 220-WSTU or 220-9798. 9897. Yeah, right.
You'll get it.
I'll get it. I've only been saying it for a while. 9788. Anyway, that's the number, and you can call in. Good morning, Peter, by the way.
Good morning.
Yeah. So for those of you out there, a couple things we'll say. We always tell you every Monday, we'll do the best we can to answer your question, but we don't have your documents. So if you're really looking for a legal answer to go to court, even though Peter is one of the top guys around, he can't read your mind or read your documents if he doesn't have them. So we'll do the best we can based on your interpretation of those documents, and some of the facts you give us. But we know that those documents can be very confusing. They can be conflicting sometimes, or they can mean things differently than what you think on face. And so it is true that a legal document, sometimes the commas make a difference. And so if you've got really something you need to get a hard and fast answer on, then give Peter or your attorney a call, and he'll sit down and go through those. But otherwise, we will give you the best answer based on all of the facts and all of the laws and all the laws and rules and regulations. So, and we'll do the best we can on that. We also will generally talk a little broader than your particular issue, because we want to make sure that you have, that other listeners who have maybe a similar problem but not exactly the same problem, get an answer as well. Oh, dry throat this morning. Anyway, so that's kind of the spiel here in the morning. So just wanted to go through that. And again, if you have a question or want to call in, 220-9788, 220-WSTU. Peter, I figured something out. And Evan will probably, he knew this already. Did you notice how commercials have gone in the radio business have gone from a minute now to a minute and 20 seconds? See, a minute to go to the bathroom. Now you got 20 seconds. You got to wash your hands. See, in the old days, they just ran right into the, but we're keeping right on time. I mean, we're very meticulous on this side of the show, making sure that everything runs like clockwork. But
broken clock.
Yeah, right. So
twice a day.
That's right. Hey, so yeah, that's right. If I'm lucky, one of the times I'm probably off. But anyway, I know that we've been talking about a lot of things on the show for the last few weeks, and usually we're out 2 or 3 or 4 weeks, but ahead, kind of looking down the road, or some months down the road. But lately we've been talking, of course, about some of the issues that have arisen as a result of the coronavirus, which is important. One of the things that I will mention, and I don't know if you saw this or not, Peter, but we've had an executive order, which has delayed the reporting date for financial statements. So you didn't have to.
It told the time period.
Yeah. So
but now that's been rescinded as of today.
yeah, as of today. What do they? I mean, people are still at home. You still got CPAs working out of their house, and they're supposed to have these things done in a day or two. I mean, the notice came out last week. I was amazed. There's some CPAs that are just floored by it. I guess the division of timeshares hasn't really followed suit with that. I mean, the timeshare people haven't really followed suit with that yet. I don't think. But yeah, it's amazing. I mean, the reason that they had this whole thing was that you got CPA firms with people working out of their homes, and you got associations that are having Zoom meetings and not wanting you to go into their offices, and then all of a sudden I guess they don't really understand what we do, because I guess they figure we can just write a letter or something and we're done. I don't know, but
well, if you had until the end of April, and that order came out, if I recollect correctly, the original order I think was March 27th. It was something like that. So it started tolling it then. Now, some documents have an earlier period of time. So what the statute says is, I believe, if I recall correctly, you have 120 days, from the end of the fiscal year, to get the report prepared and either out or a notice to your owners that it's available for review at no charge. So now some documents have an earlier time period, which means you have to go with the earlier time period. Or the later time period, but whatever. Your documents would supersede the statute if your documents had a different time period. Otherwise, it's the 120 days, which is roughly 4 months, right?
yeah.
So if it's tolled on March 27th and your documents were silent or followed the statute, then you would have until the end of April, roughly. So now that it's rescinded, you would still have, assuming that was tolling, would pick up again, you'd have another 30 days. So it's not like you have to do it tomorrow, but you're right. I mean, not being an accountant, and people still, all over the place as far as they're working and everything.
Yeah.
But why was it rescinded? Kind of out of the blue, quite frankly.
I don't know.
Nobody really knows. Nobody really knows.
Well, I could.
Part of it, the rescission really affected two things. It affected the financial reporting requirement as far as getting that out, and the whole issue of the emergency powers under the statute 718, 720. Although 720 they didn't have jurisdiction even to do that to begin with,
right?
But they did it. 719 as well, but the more jurisdiction there. So they originally did it to try, I guess, to clarify the emergency powers with respect to the coronavirus health emergency, and it was, whether it was legit or not, it was somewhat helpful. Okay,
yeah.
Whether the division had the authority to do it, they did it. Now they rescinded it for reasons that were not really explained. So now we are where we are. To use a trite phrase.
For us, we were, most of our stuff, we were out of, we have a lot of off-season work anyway. And for us, a lot of our stuff, we were pretty well into it by the end of March, and we got most of ours. We got a lot of ours finished up. We just got a few loose ends that we've been waiting for. So it won't be too bad. I mean, in our situation, it won't be too bad. But I know there are a lot of firms that are struggling with it, because if you're not set up to work remotely, then it doesn't work. It just doesn't snap a finger and all of a sudden you can be efficient, work remotely. And there's a lot of issues. I've seen a couple things, and it bothers me is, as CPAs, we deal with a lot of we deal with a lot of confidential information and information that can lead to identity theft and things like that. And I have a fairly elaborate system. I pay a lot of money to have my information secure in a cloud with a reputable and high quality firm that does that. But others just, some of the smaller people, they just tried to go home and use, go to my PC or whatever. And you can't, you just don't have the safety measures in place for some of that kind of thing. And so I have some real concerns about some of that anyway, about that information being available. And I've seen some statistics talking about hacking during this period of time. And it is something I think that's probably appropriate for associations. You have a lot of confidential information in your association. We try to limit what you have, but but there's information that's available. And so you need to be aware, even in your own situation. A lot of associations were not cloud-based. They had their own little laptop, or they have even better yet, a desktop in the office. And now they're trying to set it up so that somebody can log on to it from remotely. And you need to be careful about the data that's available to people, and some of the things that can happen out there. And so I just, that's one of the things I know I've been worried about right now with all. I'm not worried about on my system because of the way we're set up, but I do worry about a lot of small firms and a lot of people out there, a lot of associations that don't have the protection. And I'll give you an example of just years and years ago. I've always been cloud-based, but for a while I managed my own cloud. In other words, it was I had a software company that came in, and we actually put together, and they put together a cloud-based system. And I had what they call, I had some hardware based systems that protected people from getting into my computer and things. A lot of stuff is on computers is software based, and so software, of course, can be hacked. Hardware is pieces of equipment that have to physically be adjusted, turned on, turned off, so things like that. So anyway, so I had that for a long, long time, and and I had it set up that way, and I had I never had my system hacked, but what was happening is I had a group of there was somebody who hacked the internet interface. In other words, they didn't get into my computer, but they got into the interface of the internet through one of my firewalls. I had a second, I have two firewalls, and so one was for email stuff, and they got into the email portion of it. And what they ended up doing was sending out thousands. They were sending out 3,000 emails. I think it was 3,000 emails a second or something like that was going out of my system. And I couldn't figure out why my system was running so slow. And it turned out that that's what it was. I was almost banned because a lot of that stuff was things coming out of, all kinds of crazy stuff, like porn and all that kind of thing that goes through, where these guys, mask where they're sending it from so that they won't get caught. But it was interesting because, you don't realize this stuff that can be happening if you're not really into that type of system. And if I'd have had just a software system, they would have hacked all the way into the system and gotten into my information. So it is something that's important to be aware of while we're in this kind of electronic change or electronic transfer. And that's I would encourage associations to take an opportunity to look at cloud-based systems, and not just cloud-based software systems, but cloud-based systems for everything. It's funny. We got this whole thing with people working at home, but we've always had problems with hurricanes and disasters, and people's records getting destroyed. And frankly, there's no reason for that today with the technology that exists, and it's fairly affordable to have a cloud-based system where you can scan documents, have them in a cloud. They're backed up automatically. They're not located per se on site. They're located in a cloud that's accessible from on site or from other locations. And it is a much better way to secure your data. You don't have to worry about the property manager running into the office and pulling out the computer and putting it in the back of their car and driving up to Georgia during the next hurricane. You just don't have to worry about those things. But anyway, so I did want to talk about the fact, though, that we do have this reduction of or the change. The other thing I was going to mention is it's kind of not directly condo related or HOA related, but it will in effect have an impact. I saw this last week that the state's revenues are they're way, way down. The state of Florida is largely dependent on sales tax revenues, and there's none of that coming in, or nowhere near what there was coming in. And of course, we talk about how our businesses missed the season down here in South Florida. Well, the state missed the season in South Florida for sales taxes. There would have been a lot. Now, this week, I believe, is the hurricane-related sales tax exemption. So there's going to be products sold this week, and there's not going to be any sales tax on it. So the state is really, really hurting for money right now. So just keep that in mind. I suspect usually when the state hurts for money, all of a sudden the penalties start getting enforced, and that's where they, get some of their revenue from. Anyway, so just I just want to throw those out there. We are looking at some financial issues in the state of Florida, so I would be I'd be prepared for that, and making sure that everything's all squared away. And then the other thing that I guess I would throw out to you, Peter, in terms of questions, but I know that right now there's it's still tough economically. What kind of things do you think associations should be doing to, first of all, handle collections and do some of those kind of things, but and what kind of concessions can they make? And then the other thing is then physically securing the premises, whether that's from VRBO type situations or from really people getting on property and trying to just either be on property, sleep on property, cause problems on property and that kind of thing. I know that we hate to talk about it, but here in Florida we have a fairly large homeless population, and from time to time that becomes more of an issue. And I'm particularly worried about what's going to happen when we start having, if we start having any storms or whatever. So, what's your thoughts on some of that, Peter?
Well, on the collection side, associations, when all this started, there was a general feeling that the associations were going to, I don't know what the right word is, but relax some, I guess, on the enforcement of collections, knowing that a lot of people are struggling due to furloughs and layoffs and everything that's happening. I mean, we all know what's happening. Unemployment has skyrocketed over the last 4 months. Now, it doesn't mean that associations, obviously, they need income to survive as well, right? Mm-hmm. So they can't, legally, they can't just waive assessments. They can't just reduce the amount of assessment. I think what they can do is, they can, I believe anyway, that they can waive interest, late fees, not the actual assessment itself. Perhaps if they can enter into payment plans, be somewhat lenient, I guess, in that regard. Again, it all depends upon, the association's own needs, paying their own bills too. Mm-hmm. Everything kind of slides downhill, right?
Right.
My own associations, which is obviously the closest thing that I hear, as far as I know, things have been okay. I think collections have upticked a little. I haven't seen an avalanche. We'll see, I guess, the longer this goes on. But I think, again, I think associations can work with their owners, mostly with respect to, timing and interest and late fees and, those kind of things, to try to, work it out for both sides. Mm-hmm. As far as security goes, especially with, the hurricane season coming up, right? And it's supposed to be a really, really active season. As far as security, and obviously that's going to depend upon the way the community is set up. Are you gated? Are you not gated? What can you afford to do, quite frankly?
Peter, on that, I know a lot of that on security, gated versus non-gated and all of those kind of things, that is something I want to get into, but also, the whole question too of just, monitoring access to the, monitoring access to the process, monitoring access to the property, not only gated and non-gated, but just who's coming and going relative to guests and people like that, because I think that's an issue. But let's see, we got a call right now. Let's take a break from that. We'll come back there and we'll take our caller. Frank, go ahead.
Morning.
Morning.
Morning, Frank.
I have a question for Peter. This is about 719 co-op, but
Okay.
say we have an election August 1st to elect new officers, right? And I'm just making up these dates, but now there's 3 openings and 4 people applied so far. And the cutoff date is June 1st to put your application in to run for the board. Now, suppose one of the applicants decides on June 3rd not to run, and there's 3 people for 3 positions. Now, can the board make some kind of different change and say, oh, well, we could make up another rule all of a sudden, or?
No. I mean, once the deadline passes, the deadline passes. If that person withdraws in writing, now you have 3 for 3, so there is no election.
All right, so the board just can't make up a rule. Well, we're going to extend it another 30 days, provided there's no rules in the bylaws or master.
No, because the statute would control, and basically once the deadline passes, the deadline passes. And if that withdrawal came like that, as you said, now you have a 3 for 3, so there is no election.
Okay.
It doesn't extend the time period for people to submit their names.
Well, yeah, you never know with this board. They're always up to something sneaky, but you know what I'm saying?
Well,
so that's why I wanted to ask you.
I'm
legally
just saying that's the law. So, everyone had their chance, right, to put their names in.
But Peter, couldn't the board go out and hire an independent party to determine, maybe to step into the role of a board member for that person to determine where they should go going forward? I mean, I've heard of at least one court that's doing that. So
there you go. That's what I'm saying. Some kind of strange rule that they might come up with, or
no, I don't think
so.
So
you can nominate some Supreme Court justice who isn't already qualified.
That's right. I think so. That'd be true.
And they can't keep the person who's dropping out name on the ballot. And then when you get elected, there
should be no ballots going out, because
there should be no ballots going out, right? Yeah.
So that's it's
it's a trick. I never heard that one, but it's a tricky one, and I just wanted to make sure.
That it's funny, that does happen from time to time. They'll get you get somebody who gets encouraged to step in, and then because they're afraid somebody isn't going to run or is going to run or whatever.
Exactly.
And then
Boston, they beg to run. Please run.
Yeah.
We don't want this other person to get in.
And then, but and I've seen strategies. I hate to say it, but I've seen strategies where, groups have purposely done something like this to kind of discourage or block. There's a lot of people that don't like to run in a contested race in a homeowners or a condo association. They just don't want to go through that because that's where they live. They don't want to get into that, and then they feel bad because they're volunteers and they feel bad if they lose. So, I've seen people do that where they'll make sure that it's a contested type situation, hoping that somebody will drop out, that they don't want to get into that and the time and effort that it takes to run in an election like that. So it's but with only 3 seats and 3 candidates, you're done. You guys are finished.
Yeah, as long as it's legal, but I'll see if it ever comes up. Got another question for you, Peter. We got a rule in the bylaws that you can buy another house and another share if the board approves you. That's in the bylaws, right?
Mm-hmm.
Okay. Now they have rules and regulations, which a few years ago they made a rule in the rules and regulations. And it said that one of the houses that you buy has to be up for sale. In other words, they don't want you to own 2 of them. If you buy another house, either or has to be up for sale. Now,
your bylaws say that you can own 2, right? As long as you're approved.
Right.
Correct? Then they passed
another house, not necessarily.
Then they passed a rule. Hang on. Then they passed a rule saying that if you buy a second, you have to sell one of them.
No, one of them has to be up for sale. If you're going to
Well,
own
same
two,
thing.
yeah,
Same thing. You have to be selling
One has to be up for sale. You got to sell one or the other.
right.
So right. So you end up with one because if
Right.
you're buying a second, well, I would say that rule is invalid because I would say
Oh.
that rule conflicts with your bylaws.
Well, that's what I was going to ask you.
And in order for rules to be enforceable, and co-ops are a little different because they don't have declarations, but they still have bylaws and articles. And they have proprietary leases or agreements, or usually something to that effect. But in order for a rule to be enforceable, and this
Right.
goes for condominiums, homeowner associations, and cooperatives, in my opinion, for a rule to be enforceable, it has to be reasonable, and it cannot conflict with any express provision of your other documents. Usually that's your declaration of condominium or your declaration of covenants and restrictions, or in this case, the cooperative bylaws. It can't conflict with anything expressed in there or any right that's reasonably inferable from those documents. So here, according to what you said, your bylaws expressly say you can own two. So I don't think you could put a limit on that or a restriction on that through your rule. You'd have to amend your bylaws to impose that type of restriction or that type of limitation that one of them be up for sale, because that's a restriction on your right that's in your bylaws, in my opinion.
And Peter,
So I don't think that rule is enforceable.
Peter, is there how would you or legally, how can you keep somebody from buying a piece of property? I mean,
You can. Lots of documents that say you can only own one unit.
that seems kind of just basically
No,
discriminatory.
I think those restraints, you can argue it's unreasonable. I don't think you can do it through a rule, okay, but I think you can do it through your declaration. Now, declaration provisions can be to a degree unreasonable. They can't be arbitrary, they can't be capricious, and they can't violate any constitutional right. So, the reason they do that is because they don't want investor owners, right? They don't want someone owning 10 units or 20 units,
Right.
and renting 19 of them.
But wouldn't you just control that through the rental restrictions rather
No,
than
you can do it. I think you can do it both. I see your point. I don't think it's necessarily an unreasonable restraint against alienation. I don't think there's any right to own multiple units per se.
Yeah.
And there's many associations that have a similar provision to that.
Even if your husband snores really loud and it's not enough to be in the other bedroom, they have to be in another unit down like a block away or something. Is that a good reason? That might be a good reason, right?
Yeah.
Now, I can't, frankly, I could see the controlling the leasing situation so that you don't have a bunch of investors. But, if somebody wants to buy a couple units for whatever reason, maybe they're going to own a couple units, because I could see, for example, if you had your parents there, and your parents are going to be in, so you want your parents in a unit, and you don't want your parents to own it. There's no reason for them to have assets in their name at their age. You might as well, usually you've got it in some other, either owned by a trust or owned by another family member who's letting the parents live there. I have situations like that a lot of times where, the kids have maybe the wherewithal and they want the parents nearby. And so they've got a couple different units in the association where, their parents live,
Well, that's what started in my community. It's exactly what happened.
Yeah, that's what.
They wanted to buy a place for their
you
parents,
can always
and
make pro and con arguments for any restriction. Okay.
So
all I'm saying is, I think, again, I'm not saying
that rule is not an addendum.
I'm not saying that
a conflict.
Should limit how many units anyone can own. That's up to each community. All I'm saying is, I think that type of restriction in your declaration of condominium, in your declaration of covenants and restrictions, or in your cooperative bylaws and/or proprietary lease or something like that, I think that restriction is enforceable. Should you do it? It's a whole other story.
Yeah.
But I don't think it's arbitrary. I don't think it's capricious. I don't think it violates any constitutional right. And that's the standard. It can have a degree of unreasonableness to it.
Right.
Okay? Unlike a rule must be reasonable. So I don't think you could do that through a rule. Okay? I don't think you could pass a rule saying you can only own one unit. That would not be enforceable,
right,
in my opinion. But in your declaration or in your cooperative documents, not your rules, I think it would be.
Okay. Yep.
So you would actually have to change it in the bylaws instead of putting it in the rules that you have to sell one house or the other.
Yes.
Okay. Now that rules should be eliminated from the rules and regulations, right?
In my opinion, yes.
I mean, they should eliminate it, which they didn't do, and they let somebody buy 2 houses, which was my confusion of why wasn't it enforceable. And the other question is, as long as we're on that, what kind of restrictions can they do to you if you wanted to buy 2 houses and they say, well, no, we're not going to okay you. Meanwhile, they're okaying other people. I mean,
well, it can't be. I mean, I'm not sure why they would.
How could it be arbitrary?
I don't know what the reasons are. Obviously, the reasons would have to pass whatever reasonable criteria they had on why you can't. I mean, why one person can own 2 and one couldn't. Seems to me, absent some pretty darn good reason, they
would be my legal
they have
response.
to treat everybody pretty equally. You know, maybe they could say, I don't know whether the documents would say that you have to pass some type of financial responsibility type of criteria, and they decided that this person doesn't have the financial wherewithal to own 2. You know, and it's something objective, not relatively objective, not just some, you know, arbitrary BS thing. Excuse my use of phrase BS. But as long as it has some legitimacy to it, but, you know, on the face of it, I don't know why they turned down one and the other. I mean, that's something that has to be looked at a little more closely.
They have to give a legitimate reason, right?
Yeah, they have to have a legitimate reason. They couldn't just, you know, be arbitrary and capricious or
we don't like you. We don't want you having another house. They can't say something like that, or. But we don't like you. We don't want you to have another house. They can't use that.
Well, obviously, they can't do it just because they don't like you. I mean, that's just childish. I mean, just because.
Well, these boards are.
I'm just saying, just because someone happens
all
to
kinds
be
of stories.
an unlikable person, or has been a dissident in the community, or a perceived dissident, or perceived blankety blank in the community, obviously that's not a reason to not allow someone to buy a second unit. That's completely irrelevant, or should be.
I think though that you can,
except for Breckville.
Yeah, that's right. I think you can in this situation. I think you probably can make use of the Flusy rule, which says that if you have a spouse who's 25 years or more younger than you, they're by definition they're kept out of the community. I've seen that Flusy rule enforced from time to time, and that's it. That's in the bylaws, I think. No, that's in the rules and regulations. But yeah, I've seen that one from time to time, especially in those 55 and over communities. But anyway, no, I think that it is. You know, it's funny. Sometimes people just don't think these things, and I think you pointed out very concisely, Peter, that there's a hierarchy in this process, and as you go up that hierarchy, they carry more weight. And that's why generally they're also harder to amend.
Right. Anything that you want to give some assurance of enforceability, relative assurance, put it into your declaration. Okay. Anything that's in your rules is going to be more subject to challenge. It just is, because it's subject to more scrutiny. It's subject to the test of reasonability, and reasonability can be what? You know, what's reasonable in my eyes might not be reasonable in your eyes.
Right,
especially me and you. But but when it's in your declaration, it can you're more on, again, what I said before, you know, is it arbitrary, is it capricious, or is it unconstitutional, or something, you know, to that effect. It's subject to much less scrutiny than it is when it's in the rules.
Yeah.
I also want to ask you on the same thing, which I don't believe there's anything in the bylaws or rules and regulations that says anything to this, but you have a husband and wife. Now, if the share is in the husband and wife's name, and I guess they could split it up and put one house on the husband's name and another house they want to buy in the wife, would that be legal?
Well, that depends. That will depend upon how the declaration, or how the bylaw for co-ops now, not for HOAs, are kind of, how the provision's written. If it just says, you know, that, you know, one person cannot own more than 2, then you could split it into husband and wife, right? But if it was written to the effect of one person, nor spouse or any relative, or does it, if it was written to encompass the husband and wife or something like that. So it all depends the language that was used for the restriction. I mean, I've written restrictions like this, and sometimes they want to say, we don't want any family owning more than one unit. In other words, you want to make sure it doesn't happen the way you just described it. So the husband and wife can't split them up, or the kids. In other words, the husband owns one, the wife owns one, the son owns one, the daughter owns one, and the family ends up owning, 4, 5, 6 units.
Yeah, they have a block.
So I've written them. Sometimes I've seen them, and sometimes I've written them where it's broader than just person A can't own more than one. So it really, again, I'll give kind of a long answer here. It depends upon how the restriction is written as to who it applies to.
Yeah, right. And a lot of times, if you've got a set of documents that are older, they won't have restrictions in them for things like corporate ownership, trusts, and things like that. And so a lot of times there's ways to get around ownership through that process.
And I've had to write them where you can't be, no one, no one in your family can be a shareholder, principal, blah, blah, blah. So you try to encompass all that too.
Yeah.
Look, any restriction you write, unfortunately, it's going to sometimes be subject to certain use and overuse loopholes or whatever. But
and I think, Peter, especially nowadays, when you start getting into limitation, that's why I brought this up on the front side of it in terms of discrimination, is because nowadays the definition of family is quite a bit different than it was, 40 years ago when some of these documents were originally written. And I even I know in the city of Stewart a while back, a few years back, maybe 6 or 7 years back, they were trying to define, they were trying to really, the purpose was to try to limit not VRBOs and those kind of things, but they were trying to limit the amount of the amount of rehabilitation facilities that were in town, drug rehab facilities and things like that. And so they were trying to restrict occupancy to family members so that they, could kind of weed out these facilities that were leasing beds to, to other people coming in for the treatment. And I remember at the time, I mean, they're trying to define, and in the tax code there's a whole definition of all this stuff, and it's very hard to define because of what's considered a family unit now, and discrimination relative to gender or whatever, and so it's very hard sometimes to avoid stepping on some constitutional rights that you might have. And so you got to look at some of that kind of thing too, because certain people can't be discriminated against, and it's, so for example, if you've got a community that's not a 55 and over community, and the person that's trying to buy is under 55, for example, and you're just trying to arbitrarily, maybe your community's trying to move that direction, you're just trying to arbitrarily keep that person out, you may or may not be able to do that. That might not be a protected class if they're young enough, but, if they're 50, or so, you still have housing requirements that you've got to allow people to buy a home. You can't discriminate against them because they're a single mom or whatever the deal is. So
no, that's very true. I mean, obviously, you always have to be conscious of whenever someone is getting denied, are you violating any fair housing laws? Like here in Palm Beach County, we have our own local housing ordinance where age is a protected class. Mm-hmm. Age is not a protected class at the federal level. Okay, so certain counties have their own housing ordinances, their own fair housing ordinances, and also here in the county, you can't discriminate based on marital status. Okay, so 2 unmarried people are allowed to live together. There's other counties, I think in Broward and others, you can't, I think maybe in Palm Beach as well, where you can't discriminate based on sexual preference. Okay, so those, you can't discriminate against those who are gays. And I mean, I think down in Broward, you can't discriminate based on political affiliation. Okay, so you want to keep out Democrats or keep out Republicans.
Well, that's crazy. That's just crazy. That's just crazy.
I know, but I'm pretty sure it's in their local ordinance. So not only do you have to look at the federal and the state housing laws, but you also have to look at your own local jurisdiction and see if they have any other protected classes that aren't listed.
Yeah, that's why I tell you, Frank, that's why, when you get into these kind of things, I think boards are wise to try to be as broad as they possibly can and not, because there's just, we talked about this hierarchy, and Peter just just indicated once you get through your documents, there are other laws that come into play. And of course, the U.S. Constitution is kind of the ultimate.
Yeah.
And so, people start playing with fire when they start trying to, mess around with things, trying to target certain people or certain groups. And I kid around a lot, but I have seen associations actually try to do some of the things I'm talking about. The floozy rule I didn't make up. I've seen it enforced places, and and it's just it doesn't carry any water. You just can't do some of those kind of things. But and then that's how associations get themselves into trouble. And usually the problem with that is that once they do something stupid like that, then they come under some kind of sanction that's worse than what they started with, because now they've kind of been idiots and they get into trouble for it. So, it's tough, but you can't, anytime you arbitrarily discriminate against one person in your community versus another, you're asking for trouble in that situation. I think if there's not some sort of very, very good logical reason, that's not just something that's kind of out there, that's more of I don't like this person type thing, you run a risk that you've got a lawsuit coming. So it's kind of crazy, and I don't think it's good business practice. I mean, if somebody actually loves your community enough that they want to own more than one unit there because they want their family to be there sometimes.
Yeah, any disapproval, almost any disapproval, you should run it by your attorney.
Yeah.
Any disapproval may be fraught with potential problems. No matter how reasonable you may think it is, when I say you, the board, the only real clear-cut justification to turn anyone down, everything else gets a little bit subjective, is number one, your documents have to authorize it. Okay, you'd be surprised how many associations turn people down, and there's nothing in their declaration about turning people down. They just do it because it's how they've always done it, for some crazy reason like that. So assuming even though, number one, you have the authority, the really only ironclad reason is if the person doesn't qualify in the face of their application to own or occupy, i.e. you're 55 and over, and they're not the right age to occupy. Okay.
Right.
And they insist on occupying. In other words, they're not just going to leave it vacant. Or you have a bona fide restriction against trucks. Okay, not just something made up, but something that's bona fide in your documents, and they insist that they're going to, park their F-350. And well, they can't because you're not allowed to. But short of their ownership or occupancy creating a violation of the documents, everything else is subject to interpretation.
I believe the Second Amendment allows me to own an F-350.
Oh, here we go.
I'm pretty
the
sure.
Right to bear trucks.
The right to bear my arms.
Right to bear.
And hand them out the window while I'm driving my F-350.
Yes.
So.
Your assault rifle.
That's right. That's right. I think I'm allowed to do that. I would take your comment one step further, Peter, and not only any denial, but I would say anytime you're making an exception, even if your rules allow for the exception, I say anytime you're making an exception, it might be a good idea.
I agree with that too.
Run that
talking about approvals.
Yeah, right. No, I agree. But I'm just saying, anytime you're making an exception to what is the normal practice, I would, even if you think you've got the reason to do that, just for the reason that you just talked about. Sometimes people think they have the right, and they don't realize that they don't. So
right.
they're making an exception that they think they can make, and they really don't have the ability to do it, or they're.
I see that. I make fun of it, but I see that all the time.
Right.
Particularly with homeowner associations, because condominium associations. I'm not saying all. You have to look at your documents too, because there are many condos where there is no right to approve leases, or there is no right even sometimes to approve sales, and you do see it. But in HOAs, it's very frequent that the documents don't have approval rights of sales or leases, and boards or associations for some reason assume that they do. Okay, just because they just make an assumption that sure, we have a right to approve who comes in here, and you might not. So the number one thing is to look at the threshold authority. Is there authority to approve or disapprove? And then you go from there.
Yeah, and you also have to look at what you may have to do if you disapprove. Is there
a right of first refusal? Do you have to
right.
furnish a buyer or not furnish a buyer? Things like that.
Yeah, the more if you're taking the position, I can just refuse somebody's sale, and you don't have any requirements of just a right of first refusal or something, that they can then go through with the sale if you don't buy it, or if you don't find a buyer for it. If you just in your documents you basically just say, no, we have the right to tell you can't sell your unit. That gets pretty tough. Somebody that gets pretty tough. It can be, I think, probably defended, but the more you leave the person hanging in the wind without being able to get out of their unit, the more problems you probably got.
Yeah, this is a frequent area, and I'm not pushing this necessarily, but this is a frequent area that really needs document review for potential amendment.
Yeah.
Okay. To clarify, specify, the rights of approval, disapproval, and the grounds of approval, disapproval. Okay. Which, in my opinion, should also be set forth in your documents and not just left out for, boards to just decide, on a whim. Those things, in my opinion, should be in the documents.
Right. So, yeah. So, but anyway, so that's I think that's a good point. Frank, I think those were some good questions, and I appreciate you calling in. That's those are some interesting things, and frankly, there are things that happen at a lot of associations. So I'm glad you brought the question up, because, as Peter's pointed out, this isn't something that just arbitrarily happens every now and then. It's it happens more often than not that there are things like this that come into play, and again, people just don't always read their documents or don't understand their documents, and I find, I don't know about Peter, but I find that boards sometimes believe that their rules are more important than anything, because they have control over those, and don't realize that many of their rules probably aren't even enforceable because they're in conflict with their documents.
Yeah, because the rules, although the rules are one of your documents and are enforceable if they're done right, but they are the caboose in terms of the hierarchy. Okay? And that's why you got to be careful when you adopt rules or amend rules, that you're not adopting them in conflict with your declaration. Again, either expressed or inferred.
Yeah, rules are kind of, and I think it's important to understand that rules are out there to kind of
they're supplementary.
Supplemental, give direction without being conflicting to your other documents. In other words, if your documents say, you can, you're limited to two dogs, right? You're limited to 2 dogs. So you've got a restriction on limitations on dogs. Rules then maybe could clarify that. Maybe that's 2 dogs under 50 pounds.
Nope. I would not do that in a rule.
Well, I know, but I'm just saying.
I'm just saying right now, I would not do that in a rule. If I was going to put a weight restriction, I would put that weight restriction into the declaration. Now, maybe with dogs, you can have maybe a rule that would say, you got to pick up after it or something.
Yeah, that's right.
But anything substantive about those dogs, I would put into the deck, not by a rule.
Yeah. So, I was trying to think of something like that. So that's probably a better example is you got to pick up after your dog. You got to run them around the property in a stroller, whatever the rule is, something less restrictive than that, I guess. But anyway, so, it was a good discussion this morning. I appreciate it, Frank. Appreciate your calls. And we're here on Mondays to help you guys out. We're always here to try to give you some advice and see what we can do to help. And we'll be here next Monday from 9 to 10 o'clock to try to give you some additional information right here on Condo Solutions. Like I say, every Monday from 9 to 10 o'clock right here on WSTU Digital 1450. We're Martin County's Heritage Station.